We are very blessed to have Dan Kniffen here. He's an attorney that's been working on workers' compensation defense for over 33 years. Great deal of experiences, and again, talk about the topic of why do we really know who your employees are? So everybody, welcome Dan Kniffen.
Thank you, Dan, and thank you, everybody. Good to be with you. Hope everybody is doing well. It's good to be back. I've had the pleasure of doing a few of these webinars in the past, and I have to say it's nice to be talking about something other than COVID, other than whether that's a compensable claim and what all the various issues are. If you still have questions about that, let me know. We'll be glad to talk to you about it. But what we're here to talk about today is a topic that does come up from time to time. It's, I guess, probably the main reason to talk about it is that it is simply not one of those issues that is as clear or as commonplace or as obvious, maybe, as you might think. So we're going to go through this issue, who your employees really are for workers' compensation purposes. As we go along, this is meant to be interactive. We're going to have a couple different scenarios that we'll walk through in a few minutes. At any point in time, as you have questions, please feel free to ship them to Dan. Dan will be fielding those and will pop those in for me at any point that he gets them. So with that, let's jump into this. Who are your employees really for workers' compensation? Pretty sure everybody on the webinar here today has dealt with workers' compensation enough to at least know kind of the general rules for what constitutes a compensable workers' compensation case. And there's a whole lot more to it than this, but just the general framework from the very beginning, and we've had workers' compensation for about 100 years now in our state, is just these two first things that you see. You have to have an employment relationship, which is what we're going to talk about. And there has to be an injury that arises out of and in the course of employment. And as you probably know, if you've been around any of these webinars or the training that we do with the cities and counties on workers' compensation, we spend most of our time on that second point. You know, did the injury happen on the job? Is it something that arises out of our employment? Is a heart attack a compensable claim or not? You know, various issues like that. The one we don't tend to spend as much time on, because it frankly doesn't come up quite as much, is the employment relationship. Obviously, there is no workers' compensation claim. There's no need to look at workers' comp if the person who's filing the claim isn't your employee. That's really the first prerequisite before we get to whether there was an accident or an injury. Somebody gets hurt on a city or county location and they're not your employee, we're obviously not talking about workers' compensation. But where a lot of employers, cities and counties included, take a wrong turn sometimes is they really haven't ever had a reason to think about, well, who are my employees? And I'm pretty sure if I was just to throw the question out there, tell me who all your employees are, most of us would simply go back and go to our payroll. Maybe we'd simply go to our personnel files, or maybe we would go to some form of tax form list, our W-2 register, or something like that, and say, well, those are our employees. And that's very common sense. That is what I think any to work for us. What we're going to see is that when you have a workers' compensation claim, that would probably work for a lot of your cases, but it will not work for all of them. And perhaps more importantly, that is not what the Workers' Compensation Act looks to figure out who your employees are. And the Workers' Compensation Act kind of looks at employment as coverage, right? Whoever your employees are the folks covered by your workers' compensation policy. So let's look at what workers' compensation does say about who your employee is. And the first thing we'll notice is that this is really much broader than what we might ordinarily think. But one of the very first statutes in the Workers' Compensation Act, which is in Title 34.9 of the Georgia laws, is that an employee means every person in the service of another under any contract of hire, unless there's some exception provided in the chapter. It goes a little further in 3497 to create a presumption and says every contract of service that we talked about just a second ago will be presumed to be made subject to the act. So one thing to do, I suppose, right off the bat is to look at this and say, well, now wait a minute. This sounds very broad. This doesn't say, for example, everybody who's on my payroll. It doesn't say everybody that I have to file state or federal tax forms for. It says every person who's in our service who works for the city or county under any contract of hire. So that's very broad. And as we're going to see as we go through this a little bit today, that's intentionally so. When the Workers' Compensation Act was drafted, you may, again, if you've been to some of these seminars, you may recall the whole reason behind it. The whole reason we have workers' compensation was to take accidents that happen on the job out of our tort system, so that if you get injured on the job, you're not having to go to the local, state, or superior court and sue your employer like you might if you were in a car accident or injured somewhere away from the job. It was meant to be something to broadly cover all on-the-job accidents. And one of the ways the Workers' Compensation Act does that is to say, all right, look, we're going to probably define as an employee of yours, somebody who's covered, as broadly as we possibly can. So almost a starting point when anybody files a workers' compensation claim against you is to kind of assume, that they're going to be given every benefit of the doubt as to whether they're your employee or not. Now, it doesn't mean that they are, but it does mean you should never look at a claim and go, this guy doesn't work for us. He works for the janitorial service that we hired. Probably, and maybe that's where they would go for the workers' comp claim, but it's not necessarily as cut and dried as that. And again, the reason is by design. The reason is to bring as many folks as possible who work for you, for your city or county, within this workers' compensation umbrella. So that's the starting point. Employee for workers' comp purposes is defined pretty broadly. Now, there's also a few provisions in the Workers' Compensation Act that are very specific to cities and counties, and it is to make sure that there are certain employees that are covered. So as you see on the first bullet point here, our Workers' Compensation Act says specifically, we're not going to look to whether there's a contract of hire. We're not looking to anything else in this broad definition. We're saying outright that firefighters, law enforcement personnel, emergency management folks, they are employees of the entity for which they work. And in this case, obviously cities, counties, perhaps the state of Georgia itself. And again, the purpose for that is just to make sure there's no question about that. We don't want there to be issues when a firefighter gets hurt, for example, about whether they're an employee or not. Some of the employees that we might otherwise scratch our heads about just a little bit are on the second bullet point. So what about elected county officers? Right? They're not necessarily hired, right? They're more like perhaps a CEO or an executive might be in a business. They're not so much an employee as they are an owner or an executive official. Well, there's a variety of folks like that, where our Workers' Compensation Act says elected county officials, volunteer firefighters, volunteer law enforcement folks, planning commission folks, and a handful of others, they're all going to be considered employees, provided that your county commission or your city council passes a resolution saying, yep, we want to cover these folks under our workers' compensation plan. And in 30 plus years of representing cities and counties, I can tell you, I don't think I've ever seen a case where there was one of these folks where the city or county had not passed that resolution. So if you ever wondered, for example, gee, what about our volunteer firefighters? Why are they covered? They're not paid employees. Well, this is why. Not many volunteer firefighters are going to sign up where they don't have coverage if they should get hurt on the job. So again, we have this very general, very broad definition of employee under our Workers' Compensation Act. And then with regard to cities and counties, we have a few specific folks that we know are covered simply because the Act says they are. But there are some other situations, and one, perhaps the main one that comes up has to do with what most of us think as independent contractors. And independent contractors obviously are folks that are not your employees, or at least you don't regard them as that. They are a separate entity of some kind that you as the city or county might hire to do any number of things. You might hire them to do maintenance. You might hire somebody to come in and do some electrical work. You might hire some painters to come in and spruce up some of the buildings. All of these folks we would think of as independent contractors, right? Because we hire them, perhaps we go out and bid the job out. These are not folks who are on our payroll. Never occurs to us that any of these folks might be our employees. But again, the Workers' Compensation Act doesn't look at it just that way or only that way. So let's walk through a little scenario here, and towards the end of it, I'll give you guys an opportunity to chirp in and see what you think. But let's assume that your city or county has hired a little janitorial service, not very big, 3 persons. There's the owner and maybe 2 helpers, and their job is to come in the evenings and clean a few of your buildings. Crew's done this for you for 5 years. They work at night, so they're not there during the day when the rest of the employees are. They're not directly supervised in the sense that you don't have somebody following them around at night like you would a crew of your employees, making sure they clock in at time, making sure they're doing their tasks. It's just a little independent agency that you have hired to come in and clean up your buildings, and you pay them monthly, lump sum on whatever the agreed price is. So you're certainly not paying them by the hour. You're not really monitoring anything that they're doing other than to make sure the buildings are clean. And obviously, if there was a problem, if something wasn't cleaned correctly, you might go to the crew and say, hey, fix this. But that's different, right, than having your own janitorial service and having them paid hourly, where you're deducting taxes and all that kind of thing. All right, so that's the situation. And then one day you come in and discover one of the janitors on this crew has had a slip and fall while cleaning one of the floors in one of your buildings, but he's filed a workers' comp claim against your city or county. So let me ask a couple of questions and feel free to bring in your answers. And Dan, just let me know what you're seeing. Is there any, the question is this claim our responsibility? I'm going to tell you, maybe we don't know, but do you think there's any way this could be our responsibility? I mean, this is not our employee. We didn't hire the guy that fell. We certainly didn't hire him. The janitorial crew hired him. We didn't supervise him. He's not going through our safety training. How could this possibly be our responsibility since, again, he's not our employee? And let me throw in a couple other variables. Does it matter, as we think through this, that you have a contract with this janitorial service? So you have something in writing, maybe your city or county attorney even drafted it, that says, hey, you guys are an independent contractor. We are hiring you to clean our buildings for the set fee of X $100 per month. And here are some of the expectations, and the contract is terminable at will by yourself or by us with 30 days notice. But right on top of that contract, it says in black and white, independent contractor agreement. Does that matter? And then the last question is, what about, consistent with these folks being identified as an independent contractor, what about the fact that you're documenting their payments on a 1099 form for tax purposes rather than a W-2? So you're not treating these folks as an employee for tax purposes, right? You're not withholding federal or state tax. You're not withholding Medicare or Medicaid. You're not doing any of that. How much more clear could it be that they're not your employee? You're not even deducting taxes for them. So what do you all think about those questions? Any way this could be up to us?
Anybody have any thoughts? This is where we have interactivity, volunteer interactivity. Anybody want to volunteer? Because there's always the option for this section option of volunteering is voluntolding. And
when I do these things, I always wish that they had done it this way in law school and kind of given me the option to not have to stand up and explain my answer, because of course that's what professors love to do to law students, is to put them on the spot. So I get it, but don't be bashful. If you have a thought, let's hear it.
I think the contract would exclude county liability.
Okay. Would seem like it, right? I mean, we've gone through the trouble of drafting a contract that says, hey, you're an independent contractor. I mean, you could argue, and I think it would be true, one of the real reasons to do that is for this exact situation, is that you want to make it clear to these folks that, hey, you're not our employee. You are an independent contractor. So yeah, that makes a lot of sense. Any other thoughts? What about the fact that they work at night and we're not supervising them? What about the 1099 form?
Anybody have any thoughts on that?
Okay. Well, let's see how this works out. And the answer to this question is every lawyer's favorite response. It depends. The answer, unfortunately, is not, oh, there's no way, whatsoever that this person could be considered our employee for workers' compensation purposes. When you have this kind of situation, and again, probably doesn't come up all that often, but what I see most of the time when it does is when that claim comes in from the janitorial service employee, a lot of employers, maybe most employers, kind of look at it, they furrow their brow a little bit, and they go, this is nuts. This guy's not our employee. He must have addressed this to the wrong place. He must have meant to file it against his real employer, and they just toss it and don't do anything with it. And that's a big mistake because, as you all know from other webinars, I'm sure, the Workers' Compensation Act requires you as an employer to at least respond anytime a workers' compensation claim is made. It doesn't mean you're admitting liability. To the contrary, many times the response, including in this situation, will be to say, hey, this claim was filed, but it's not compensable. We do not agree that we owe workers' comp for that. And you're simply meeting your initial responsibility by replying and saying, we think this is a valid claim or we don't. But most employers, and it's, again, very understandable, would look at the situation and go, we don't even know who this guy is. I mean, we didn't hire him. All we know is that he presumably works for this janitorial service, but even that we wouldn't necessarily be sure of since he's an employee of theirs. So why do I say that the answer to whether this is our responsibility or not is it depends? Well, the reason is because none of the things that I've indicated on the prior screen here, the designation in the contract that this guy is an independent contractor, or the 1099 form, or the fact that he's not on your payroll, none of that is determinative. What that means is we can't just hold up our payroll and say, see, he's not on our payroll, therefore he's not our employee, therefore we don't owe workers' compensation. Because remember, what we talked about at the very beginning, that is not how the Workers' Compensation Act defines employee. It defines employee as somebody who is under a contract for a service of hire, which is what pretty much every independent contract is, right? We've hired this janitorial service to come work on our premises. Now, we're not hiring them as an employee, but it's definitely a contract for a service for us. So it meets that part. And what the court really looks to, and what the law really looks to, are these factors that you have listed here. And there's a few others, but these are the main ones. The answer to the question of whether this employee of the janitorial service might be your employee for workers' compensation purposes really has to do with how much control that you exert over them. And the easiest way to understand this, what I've told folks for a long time, is what the court's really looking at is not what you call them or what the paperwork says, but do they walk, talk, look, act like an employee? If they do, then they're going to be covered by your workers' compensation policy. If they're really independent, they're really not under your control, they just happen to provide a service to you, then that's, as the phrase implies, an independent contractor relationship that is not your employee. So some of the things that they look at, which would be some of which are favorable to us in this situation, is method of payment. Somebody who's paid in a lump sum every month, like this janitorial service, not a whole lot of our employees are paid that way, right? We might have salaried employees, but even they're paid every couple of weeks typically. So the more it looks like a lump sum, or the more it looks like you're paying this contractor by the unit or by the piece or at the end of a project, the more that looks like an independent contractor and not an employee. I've seen a number of situations or cases actually with janitorial services, with maintenance services, with painters, with a number of other things that cities and counties sometimes contract for, where the folks were paid by the hour. Even though, everybody thought, including most times the employee, that they weren't working for the city or county. That's just how they were paid. But that's one big factor. How this employee is paid is going to be a clue to whether the court thinks they're an employee or an independent contractor. Another is the intention of the parties. And I don't mean to say that having a contract that is labeled on top independent contractor is not helpful. It's extremely helpful. And when I have advised folks on the front end of these things, for example, if this city or county had called me and said, hey, we're getting some work done, or we're hiring out this janitorial crew to work for us, how do we do this and make sure that they're not coming under our workers' comp coverage? Probably the first thing I would say is we need to have something in writing that says they're an independent contractor. So it helps. The thing to remember is simply it's not determinative. We don't get to walk up in front of an administrative law judge at the comp board, hold up an agreement that says independent contractor, and walk out with a win. And the reason for that's simple enough to understand. If we could all, as employers, avoid workers' compensation coverage simply by calling folks independent contractors, what would we do? We'd walk in tomorrow with independent contractor agreements for all our employees, have them sign them, and then say, gee, Judge, they're independent contractors. They signed an agreement that way. And obviously the fallacy of that is you haven't changed a thing about how they work for you. You're just calling them something different. So having an agreement that says independent contractor on it's very helpful. It does describe the intention of the parties, but it's not going to be enough all by itself. So one thing to take away from today is, to the extent you have independent contractor agreements as a city or county with anybody, you really should give some thought to what else do we have if the situation arises that's going to help us show that they really are independent, that they're not actually employees of ours. Just understanding that what you have on the top of the contract is not going to control by itself. Another very big factor is the length of time involved. Now, in our scenario here, we've assumed, that this service has been doing this for us for 5 years. That's a pretty lengthy amount of time. In my experience, the longer that you use folks like this, the easier it becomes for them to say, hey, I was really an employee of the city or county. I was really working for them. But what goes hand in hand with that really is not just the length of time, but are they working elsewhere? So you can imagine how different it looks if our guy who slipped and fell here for the last 5 years hasn't worked anywhere but in our building. He's only worked, and he goes to work every night and cleans the building on our premises. He doesn't do that in other buildings. This janitorial service doesn't have multiple contracts. They don't go multiple places and get paid by different people. Their only job, their only quote contract is with your city or county. Again, that's not going to be determinative, but that's going to make it look very much like where you're calling them an independent contractor and you're paying them a little different, but all they're doing is working for you. They're not working anywhere else. They're not really independent. So that, and again, not determinative, but a definite factor that a judge would look at. Another is what's called the right to hire and fire. Obviously, even with a true independent contractor agreement, there's going to be termination clauses, right? It could be, as we described here, either side can terminate, at will anytime they want to. And that sounds very much like how things work with employees. But to the extent there is in your contract a notice provision, or to the extent the task is, look, this is not coming to clean our buildings. This is a one-time painting project, and we're hiring you to come paint this building. We're going to pay you X amount of dollars upon completion of the work, and then the whole contract is over at that point. Well, that looks very much more like an independent contractor situation, right? We don't hire employees too much to just come work for us for 30 days or 60 days or until a job is done. So that's another thing a court would look at if we were showing them our independent contractor agreement, is how much does this look like how you would get rid of an employee versus getting rid of a truly independent contractor. A couple of other factors that are looked at in these situations: the more expertise the worker has, in other words, the more they know how to do something and are providing a service that we don't ordinarily provide or do for ourselves, obviously the more independent that looks. So janitorial service is not something all that unusual for a city or county, in the sense that a lot of cities and counties have their own folks who they hire and employ directly to do the cleaning of the buildings and various maintenance services. So there's not a whole lot of expertise with regard to a janitorial service that we would hold up and say, look, this is not something we can do ourselves. Obviously, we chose to refer it out, and that's fine, but it doesn't help us much in saying that they're independent, as opposed to, let's say a complicated electrical job in one of our buildings. We don't have electricians on staff, and we need an expert electrical service to come in and fix that for us. Whoever we're hiring, to the extent they have an expertise, a training, or a degree that's not common to what you do as an employer, the more independent that looks. Also, with control of the hours worked, the more you specify, hey, you're only to be here between this time and this time, the more that looks like what you tell your employees, right? When we have folks on our payroll or our regular employees, for the most part, we're telling them you need to show up at 8, quitting time is 4:30 or 5, and we define that for them. So the more that's defined for your quote independent contractor, the more they look a little bit like an employee, as opposed to, we don't care when you do this job, come in and do it whenever you want. The job just needs to get done. The buildings just need to be clean. We don't really care when you come in. And then the last factor that comes up a lot is materials and tools. For example, in our scenario here, it might very well make a difference whether this cleaning crew is using their own stuff, they're bringing in their own mops and cleaning solutions and that kind of thing, or whether we're providing them to them. And it's not uncommon at all for that to be the case, that you've hired, let's say, a maintenance service or somebody, but you're providing the lawnmowers or the materials for them to use to perform their work. The more you're doing that, the more you're providing the tools and the services that they use, the more that looks like the type of control that you would have over an employee, and the more the more likely it is that the court could find that your worker here is an employee. So in our scenario here, what's the most likely answer? I'm going to tell you it's actually a reasonably close call, and would depend on these factors again, some of which we don't have all the information for in our scenario. But I would say that what you would never want to do in this scenario as an employer is to simply dismiss the claim outright, or simply ignore it, or pretend that there's no way this is our employee, there's no way we'll have to pay workers' compensation for this. It's possible that you could, and we'd want to look at the contract. We'd want to look especially, probably a determining factor here would be whether this janitorial service was also providing services for other employers, maybe other cities and counties, or perhaps other private employers. The more independent that looks, the more likely a judge would be to find that this was not your employee, that they were in fact an independent contractor, which I'm certain is how most cities or counties would assume this case is, and would rule in your favor on that. So the takeaway with regard to these kinds of things is really a couple of things. Number one, don't ever assume that the folks who are working for your independent contractors might not have some workers' compensation coverage with you. They might. That doesn't mean they do. It does mean that you probably have some information that you have to dig out before you can really answer that question. The second thing to take away, again, is to kind of think about your current independent contractor relationships, and maybe go through these factors a little bit and think about whether there's a whole lot, for example, how are you paying them? Do you have a contract that clearly says independent contractor? Go down this list and just ask yourself, do these folks kind of look like they're really independent, or do they look like and sound like and act like somebody who's more of our employee for workers' compensation purposes? So that's the main issue that comes up with what we're talking about. Is somebody an independent contractor or not? Before we move on to another topic that also comes up, any questions about independent contractors?
Anybody have any questions? Just one, in regards to Dan, so is there again, I would assume this is a contractual issue. You have an independent contractor, and let's say that they are injured while they are working for you. That it really depends on the circumstance, but let's say they're injured, and is there a potential that they could sue the member where the injury has occurred?
Yeah, and we're going to talk about this a little bit in terms of what you want to be sure of in the contracts that you have with your independent contractor. And this, we'll talk about another in a minute. But you bring up a good point. Something you want to have with regard to your independent contractor relationships is something in the policy or in the contract that's a liability waiver that says, for example, you're going to hold us harmless for any accidental injuries that occur on our premises. This is a very common kind of clause to have in these types of agreements. There is no way to have a waiver of workers' compensation claims. That would be invalid. The Workers' Compensation Act specifically says you can't, and again, it's kind of common sense. If it were as easy as going to our employees and saying, here, sign this form that says you'll never file a workers' compensation claim against us, then that's what every employer would do, and we'd have no need for workers' compensation, and the statute really would be meaningless. So you can't force an employee to waive a workers' compensation claim, nor could you put that in an independent contractor arrangement. But what you could have is something that limits their ability or includes their agreement not to sue you outside of workers' compensation, or not. Obviously, the contractor wouldn't, only the employee would. So, and then something else to remember about that is, to the extent somebody is not your employee, then you do not have the exclusive remedy provision of the Workers' Compensation Act. So, for example, if our janitor in this scenario tried to file a lawsuit against your city or county, not for workers' compensation, but to say that, there was some defect that you were aware of and it was your negligence that caused me to slip and fall, then unless there was something in the independent contractor agreement that prevented that lawsuit, or something called a hold harmless agreement, which is what we just talked about, then you wouldn't have the workers' compensation. You'd kind of look at that tort suit, and your defense lawyer on that case might very well look at it and say, well, he doesn't look like our employee. We certainly thought he was an independent contractor, but we kind of have a choice here. We can defend the tort suit, assuming there's not some other defense to it, or we can try to take the position that, yeah, he was our employee, even though we called him an independent contractor. When you look through this analysis, he really was under our control, and the Workers' Comp Act would consider him our employee. If that were the case, then that would be his exclusive remedy, and that would actually be a defense to the tort case. But again, the better advice is, for your independent contractor relationships, you want something in there. Your city or county attorney, I'm sure would already have this in most of your agreements, that limits your liability, where the contractor agrees that he's going to hold you harmless for whatever might happen on the job. Now, that's not going to exclude intentional things or particularly egregious things, but the average negligence, slip and fall type of case, that's what you would be looking for. So, very good question. Any others on independent contract?
I don't see any other questions, so you can move on, Dan.
Okay. Well, let's go to our next topic then, which is what we refer to in workers' compensation circles as statutory employment. This comes up less frequently even than independent contractors, but it does come up, and it also falls under kind of the general category of being aware of your contractual relationships as a city or county, and being aware of who might be covered under your workers' compensation coverage. So in this scenario, let's assume that you've contracted. There's a building in your city or county that's owned by a third party, by a private party, and you've got entered into a contract with that owner to renovate the building because the city and county is going to lease that building and use it for office space. So part of the agreement is we're going to lease it from you, Mr. Owner, and we're going to come in and do some work to renovate the building, maybe knock some walls down and configure it the way we want to configure it. But as the city or county, you're not going to do that work yourself. You're going to hire it out, and you hire a variety of subcontractors to do the painting, the wiring, and some other work. So work commences on this building. Again, the city or county is not an owner of this building. It's not one of your existing city or county buildings. It's a new building that you're moving into. The owner is private. So what happens is an employee of, say, the paint crew falls off a ladder at the project and is seriously injured. He's in the hospital. So not your average back sprain kind of minor claim, but something more significant. And where claims like this will ordinarily come to my attention is that what's happened is that you as the city or county have then received a letter from an attorney saying, hey, my client got injured. You are his statutory employer, and this is our demand for workers' compensation benefits. So the question is, are you worried about this? Now, once again, definitely not an employee of the city or county, and really not even an independent contractor, right? This is an employee of a painter that we hired to come in for a couple of days to do a paint job on this building that we're renovating. So how in the world could this be a workers' comp problem of ours? Anybody have a thought on that? This is a tricky one, and again, not one that I would necessarily expect anybody to have encountered, but I can tell you it does happen. And there is a very specific answer to this question. There is another statute in our Workers' Compensation Act, and you see it on the screen here for you. It's 3498A. And what it basically says, and you can read the language, but it basically says if you are, the easy way to think of it is if you are a general contractor and you hire a bunch of subcontractors to come out and do some work, the employees of those subcontractors are your employees also for workers' compensation purposes. And the main reason we have this statute has to do with the construction industry. So this kind of scenario happens all the time on construction projects, right? There's an owner who's developing a project. They hire a general contractor to put up the building or renovate the building. The general contractor hires and oversees a whole bunch of subcontractors, right? Everybody from drywall to painting to wiring to flooring, you name it. In the construction industry, and most of those subcontractors, the vast majority of them, don't have workers' compensation coverage. And the reason for that is they don't have 3 or more employees. So if you're a small painting crew, it's yourself and another guy or two, our law in Georgia says you don't have to have workers' compensation coverage unless you employ 3 or more people. Well, you don't. And the amount of money that you're making on any given job that you and 2 guys can do is probably not that much. So not having to have workers' compensation premiums come out of that is probably helping you get along. But that would create a whole lot of employees who work in relatively dangerous kinds of work on construction sites whose immediate employers don't have workers' compensation. And our legislature's answer to that many years ago was to create this statute, which again, we refer to as statutory employment. So on any construction site in our state, what you will have is a general contractor who has hired the subs. The general contractor has their own workers' compensation insurance. And whoever is providing that coverage is looking at those job sites and trying to figure out, okay, how many subcontractors do you have out here? And how many potential statutory employees of those contractors might you be on the hook for if they get hurt? So they're literally estimating that, even though the general contractor himself probably doesn't have any more employees than his office staff, right? Or his sales team probably has more than 3 employees, but he's not really putting people out on the construction side. The other thing that happens in that situation is most general contractors, when they hire out their subs, will either require them to provide their own workers' compensation coverage, or will at least be aware that, okay, this guy doesn't have any and I might be on the hook. So they're not doing this completely in the dark. And there's a clue there, a couple of clues for our situation and how to handle this directly. And it's another aspect that I was referring to a moment ago that you really want to have in your independent contractor agreements as well, which is this. If you've got a situation where you've got these contractors, the simple solution to all of this, to making sure that nobody's ever coming after you for workers' comp coverage that's not somebody you already know as an employee, is to make sure that your contractor can show you that they have their own workers' compensation coverage. So in our example here, if this painter has his own workers' compensation coverage, that's who's going to pay the workers' compensation benefits. One of the provisions of the statutory employment statute is that you don't get to collect from the statutory employer if there's coverage already available with your immediate employer. It's only when there is no coverage there that you get to go further up the ladder and try to collect coverage. So the first takeaway from this, and again, another good thing to do for any of your contractors, is to simply make sure that they can show you a certificate of coverage or some form of written proof that they have workers' compensation coverage of their own. That way, any of their employees who gets hurt is going to go there first. They're not going to come for coverage under the city or county. The other thing about that is make sure that that's updated from time to time, at least every year. Obviously, workers' comp policies, like most insurance policies, are year to year. So somebody who shows you a certificate of coverage in 2020 may not have that coverage now. They may have failed to pay the premium, or they may have just let the coverage lapse, in which case you could then be exposed under one of these other theories. The other thing that's important, it gets a little bit technical, but I mentioned here because it's a key element of this statutory employment relationship. The key to your being a statutory employer is you have to have yourself a contractual obligation to do something. In this case, in our scenario, the city or county has a contract with this building owner. So there's a contractual obligation that we've agreed to that says, hey, we're going to do some renovations to this building. So you're then, as far as the statutory employment situation is concerned, you're like the general contractor at that point, and you are hiring all these subs. And again, I don't know how many of you, as we sit here today, will have a situation like this going on, but you may at some point in the future. And again, the takeaway is you need to think about anytime you're working with a contractor of some kind, maintenance, construction, anything that you've hired out for, and it's not who you think of as one of your employees. Think about these two things. Is it possible that these folks aren't really independent, and that they're going to be found to be our employee because they really are more like an employee than an independent contractor? Or is this potentially a statutory employment relationship where we're acting like a general contractor, we're meeting a contractual obligation that the city or county has entered into, and we're subbing out some of that work? In those two situations, you want to make sure that you've thought that through. And again, along with something in there about holding you harmless for things that happen on the site, you want to have something from your contractor that verifies for you that they have active, valid workers' compensation coverage in place. Okay, we got any questions? I know statutory employment can get kind of confusing, so any questions about that? Okay, let's go on to our last category of folks who are sometimes wind up being our employees for workers' compensation purposes when it doesn't look like it at first that they might be. So let's assume your city or county, you're having your annual festival, and you've got all kinds of volunteers signed up to cook, serve food, provide traffic control, basically do anything and everything to help run your festival. These certainly are not folks that are on your payroll. They're not folks that you're paying. These are volunteers. These are people who have raised their hand, probably done it for many years because everybody loves the festival, and they're just kind of making it go. Let's assume one of them gets hurt. Is there any way they can get workers' compensation? Any thoughts on that?
This is the point where everybody raises their hand or sends in a question or an answer.
While you're doing that, let me throw a couple other questions. So we're talking about volunteers for a festival, but there's a couple other folks that volunteer very regularly with us, right? What about poll workers? What about when we have elections and the folks who volunteer to come out and man the polls for us? They trip and fall when they're there, or they get hit by somebody backing out of the parking lot, on the election site. What about, and I'm sure some of you have used these from time to time, what about student interns or high school interns? Folks who come out that aren't getting paid, they're simply coming out to observe, maybe because they think they might have an interest in public employment or working in city or government employment somewhere in the future. We're not paying them either. They're not getting a wage. We're not deducting taxes. What about all three of these? Are any of these volunteers possibly going to get workers' compensation if they get hurt?
We have one person that has made a comment. I say they are employees for coverage purposes.
Okay. Good answer, particularly from the standpoint of, and this is where I would point all of us, going back to the very beginning of what we talked about. Understand that the Workers' Compensation Act wants people to be employees if there's some question about whether they're covered. So that's kind of the starting point. But the answer for each of these situations is, again, every lawyer's favorite answer: it depends. It is certainly possible that any of these volunteers could be considered an employee. It's also possible that a judge would look at their situations and say, nah, they were doing this purely gratuitously. And again, several different things involved here. Another statute that comes into play when we're looking at these kinds of situations, whether somebody's an employee or not, is the law literally says that any of our compensation provisions, any of these rules that we've been talking about here today, shall be, quote, liberally construed only for the purpose of bringing employers and employees within the provisions of these chapters. Meaning, if we're talking about one of these things and we're trying to decide whether this is somebody who should be deemed an employee brought within the provisions of this chapter, we want to construe that liberally. We don't want to put too fine a point on that. So that's a judge's starting point looking at any of these volunteer situations. There have been several cases where the court has made clear it's not necessary for somebody to be paid money in order to have an employment relationship. There can be other things of value that they're getting. In the case of the student intern, it might be experience. And there was another case actually that involved a city about 20 years ago where there was an otherwise retired city employee who was volunteering his time to help with some housing authority issues, was on his way to a meeting with regard to those services, and was badly hurt in a car accident. He wasn't paid a dime. He wasn't reimbursed for mileage. He was doing the work out of the goodness of his heart. But what the court looked at there was, in recognition and agreed, well, yes, he wasn't being paid anything, but the county was reaping a windfall. They determined, or there was evidence that the county, to pay somebody to do what he was doing, would easily have been spending $20,000 a year or more. So in that instance, they didn't look really at what the employee was getting. They looked at the value the city was getting and decided that, yes, he's covered by workers' compensation. The only twist there was he didn't receive any disability benefits because there were no wages to reimburse or to compensate. The only benefits he got were his medical expenses. So again, that's an example that monetary payments not really determinative. They're still going to look at the right to control. And so what really would be most determinative probably for each of these situations would be, were these people absolutely free to come and go as they chose? Were they doing this in a completely voluntary way, not under our control whatsoever? Not only not getting any monetary compensation, but really not getting anything other than their own, good-hearted and well-meaning efforts to help out. Looking at it that way, our volunteers at the festival, I think we'd probably have a pretty good argument that they were not being controlled, that they were doing this purely gratuitously, that was the entire point of it. This certainly wasn't happening during regular working hours. The flip side of that would be a couple of things, one of which is true and a factor in any case, and that would be, well, how serious is the injury? I can imagine a judge looking at a claim by a volunteer at that festival differently if the injury was, a sprain versus a broken leg. I think the more serious the injury, the more likely a judge is going to say, yeah, this was probably within your employment somehow. But with regard to the student intern, that person's getting something of value. And particularly if we were designating, hey, you can come in from 8 to 4, here are the duties you're going to perform, and really was looking very much like an employee. They just weren't being paid money. I think that would definitely be covered. And the poll worker is a more difficult question. And again, I've had that come up from time to time. I've never seen that case actually go to trial or go to a hearing, but I suspect that would be covered more times than not, especially depending upon how serious the injury is. And again, that's just because I think there is a fair amount of control there. If we're going to have a poll worker, we obviously have to tell them, here's when you're going to be there. There's going to be a certain amount of training, obviously, that they're going to go through. So it looks very much from a workers' comp standpoint like an employment type of relationship or something that would be covered. So just before I wrap up, any questions about volunteers? Okay, so just a quick recap. What we've talked about here today is kind of three different areas of folks that at first blush you would never think of as your employees for very good and very logical reasons, but who could very well be your employees for workers' comp purposes. The first group of those are folks who are independent contractors, folks who are coming on your workplace ostensibly as a separate entity, but and might not be covered by your workers' comp, but then again they might. So it's worth looking those situations over. And again, if there's any doubt whatsoever, or I would say even if there's not, make sure that they can show you they have their own workers' compensation coverage. That prevents any of this from ever becoming a problem. Same thing with statutory employment, and that just would be with regard to any projects that the city or county has undertaken as kind of a general contractor. And then lastly, anybody who is volunteer, I would call some attention to, I know that there are some police forces and other aspects of city and county employment that utilize volunteers, sometimes for traffic control, sometimes as ride-along folks. Those need a good long look because it's very likely that those folks would be considered covered for workers' comp purposes, in my opinion. So if that's an integral part of your public safety at this point or programs that you're working on, probably worth giving some thought to that about whether there's some way to exclude that from workers' comp coverage, or whether you even want to, and whether you just want to recognize that, hey, we're not paying these folks because they're volunteers, we're not paying them a salary, but we might very well have to cover them should they get hurt doing that type of work. So if any other questions, I'm more than happy to take them, but otherwise, thank you very much for your time and good to be with you again today.
Hey, Dan, we got a question here. What about
Sure.
people performing community service, employee?
Okay, community service, help me understand, are we talking about just purely voluntary, or are we talking about as the result of a conviction of some kind and they're performing community service in that regard?
Can you elaborate? Court order mandated or court
Yes,
mandated?
okay. There is an exclusion in the Workers' Compensation Act for folks who are performing work that's part of a probation or a community service direction, something like that. They are not your employees for workers' compensation purposes. I would always, and I actually have had some cases with this over the years, and we've been successful in kind of making those go away. But I would caution you too that that's an area that is worthy of some scrutiny from a safety standpoint. Number one, who's supervising these folks, and how dangerous is the work that they're doing, and what are we doing to make sure they don't get hurt? But beyond that, just kind of being very careful with where these inmates are coming from, where these folks are coming from, and playing through various scenarios if they do get injured, both from a comp standpoint and from a liability standpoint.
But again, you get into potential liability issues, right? Even if you're avoiding workers' compensation based on what you're having them do. And
correct. The other scenario, I mean, it's not my area, and I don't work in this, but obviously, so if your community service person is driving a truck or doing something and they injure somebody else, there's a whole other set of issues to think about there. To what extent might the city or county be liable for their actions if they do something? So none of that. Obviously, community service programs go on all over the place. They serve an important function, and there are ways to address each of those issues. All I'm really saying is, if you haven't already, it's worth your time to sit down, look at these programs, run these scenarios out. What happens if somebody gets injured? What's our workers' comp exposure? What's our liability exposure? And plan for all that ahead of time.
So, Dan, in the past, we've had a lot of requests for hold harmless agreements as it reflects on their other hold harmless, but this one specifically for volunteers.
Mhm.
What's your thoughts on hold harmless agreements for volunteers?
Well, again, it won't do a thing for a workers' compensation claim. You cannot say to a volunteer, hey, here's a volunteer agreement, and one provision in it is that you will not file workers' compensation against us. If we went to court with that, a judge would say quite correctly, that's not legal. You can't force somebody to waive whatever their workers' compensation rights are or are not, but also would make them kind of angry. And to most judges in the workers' comp world, they would view that, and it wouldn't be obviously, but they would view that as kind of underhanded, that you're trying to pull a fast one on this poor volunteer. What you do want in a volunteer agreement for workers' compensation purposes is not something that says, hey, you won't file workers' comp, but something that fills in the blank on these factors. Remember, we talked about what a court looks at to determine whether somebody's under your control and whether they're a volunteer or not. It is helpful to have in that volunteer agreement things that say, you understand that what you do here is completely voluntary. You are under no obligation to perform any task here. You're free to come and go as you please. And that the only things that you are subject to while you're on our premises are various standards of conduct and behavior and that kind of thing. That's very helpful to go. You might even have in there, I understand I'm not being paid or compensated in any way. Various things that simply underscore the fact that, hey, this person clearly is a volunteer. They're not here to perform a service or to get any compensation. That is helpful in going in front of a judge and trying to make that argument. To the extent what you're asking about is a hold harmless agreement for liability issues, so that what you're trying to prevent is a volunteer from saying, hey, I'm going to sue you because I allege that you were negligent in bringing me out here and having me on your premises, and that negligence caused me to be injured, so I'm not coming after you in the comp system, I'm coming after you on a tort claim. I do think those agreements can be helpful. And again, I would direct you to your city attorney or county attorney on that. There would be some thought that has to be given to exactly what the activity is that they're involved in, and how you'd want to craft that language. And those are not airtight things, but they are extremely helpful. They can discourage a lot of lawsuits, and they can certainly limit them as well.
Very good. Any other questions or comments before we let him go?
Well, folks, there's my email address also. If any questions should occur to you after the fact, please feel free to shoot me an email or give me a call, and be happy to help you if I can.
Dan, you got a comment here. This is incredibly enlightening. Thank you, Dan and Dan. So that was a great comment from Bonnie.
That's very kind.
Thank you,
Thank you
Bonnie.
very much.
Very good. Well, I'll let you guys go. Again, I'll be sending the recording and the PowerPoint presentation to all those that are registered. If you have any questions in the interim, please send those to me, and if applicable, I will forward those to Dan Niffen. With that said, thank you so much for all your participation and attendance, and we will talk later.
Thanks, everybody.